Assalamualaikum and very good morning, Prof. and my fellow teammate. We are from Group 3 for the case review, Dr. Hari Krishnan and Ano versus Megat Noor Ishaq and Megat Ibrahim and Ano 2018 MLJ 281. My name is Azrael. I will be presenting on fact that are considered relevant. For material fact, they be instructed in the case review. Plaintiff had a retinal tear, detachment in his right eye. Then the patient went to seek Dr. Hari, who advised immediate retinal detachment surgery for first operation. Post first operation, patient experienced a severe bleeding and vision problem. Dr. Hari then recommend for second operation without confirming retinal detachment. Through scan, despite plaintiff request for scan, yet Dr. Hari relied on his physical inspection. Then plaintiff initially requested anesthetist, Dr. Manabalan. Then Dr. Hari confirmed that Dr. Namazi was equivalent, which is Dr. Namazi as anesthetist on the duty on that day. Next, plaintiff underwent the second operation with Dr. Hari as surgeon and Dr. Namazi as anesthetist. Then during the second operation, plaintiff regained consciousness and bucked during surgery, causing suprachoroidal hemorrhage, SCH, leading to extensive bleeding in his right eye. Later on, Dr. Hari assured the patient that his vision recovery if the retina remained intact but did not disclose the risk of permanent blindness. Post second operation, plaintiff severe pain, ongoing bleeding, and led to his total loss of vision. Dr. Hari advised plaintiff to sit upright all the way to reduce eye bleeding in order to his vision recovery. Plaintiff sought further treatment at Singapore National Eye Centre for vision restoration. However, it failed due to his severe eye damage. For the medical confirmation and legal action, fine in this case, Dr. Hari confirmed permanent blindness in patient right eye due to retinal detachment based on medical report. Second, plaintiff sued Dr. Hari, Dr. Namazi, and the hospital alleging negligence causing injuries and vision loss. Plaintiff claimed that Dr. Hari and Dr. Namazi act as servant or agents of the hospital. Next, please. Court finding on negligence and liability, which contemporaneous document and witness testimony established no retinal detachment at the time of second operation. Dr. Hari failed to substantiate the procedure after SCH happened, which he followed ECCE, extracapsular cataract extraction, which is not followed as medical practice. Also, Dr. Hari found negligent in diagnosis, recommending unnecessary second operation and also choice of surgical procedure. While Dr. Mazi was negligent for failing to keep plaintiff fully anesthetized, failing to warn the risk of bucking, also inadequate monitoring during operation. For hospital, is liable for vicarious liability for negligence of Dr. Hari and Dr. Namazi due to the close relationship and hospital's role in the operation. Also, aggravated damages awarded for plaintiff pain, suffering, loss of vision, distress, and loss of life prospect. For a preliminary legal issue that have been raised in case, which is number one, the judge of the Learn JC was non-speaking judgment. Issue number two, the judgment of the Court of Appeal was not valid. Next, I hand over presentation to Sister Azila.
Dr. Majda and everyone. Good morning. Today I present on the decision based on the fact in the case of Dr. Hari and another. Just to touch a little bit on the past decision. Firstly, in the High Court, the judge found that Dr. Hari and Dr. Namazi negligent for failing to warn the plaintiff about the risk of bucking and blindness, as well as for their poor management of the patient. The plaintiff was also held liable. The hospital was also held liable under vicarious liability because the doctors acted as its agent. The plaintiff was awarded with 200,000 in general damages, 1 million in aggravated damages, and 8,014 ringgit in special damages. Next, in the Court of Appeal, the earlier decision was affirmed. The court held that Dr. Hari wrongly advised the second operation, and Dr. Namazi failed to keep the patient properly anesthetized. The hospital was also found liable under the doctrine of non-delegable duty. Finally, in the federal courts, both the doctors and the hospital appealed. The doctors argued that blindness was due to retinal detachment and that aggravated damages were wrongly awarded. The hospital argued it should not be liable since doctors were independent contractor. However, the federal court dismissed both appeals. It held that Dr. Hari and Dr. Namazi were negligent in their advice, diagnosis, and treatment, and that hospital owed a non-delegable duty of care to the patient. In conclusion, the decision of High Court and also Court of Appeal were affirmed, and the damages awarded to the plaintiff remain 200,000 in general damages, 1 million in aggravated damages, and 8,400 ringgit in special damages. For the next slide, on the ratio decidendi, it will be presented by my learned friend, Brother Agus.
Thank you, Azida. I will be presenting Oratio de Serendai. To start my presentation, there's two preliminary issues in this case, as mentioned earlier, whether the judgment of Leonard JC was non-speaking judgment, and two, whether the judgment of Court of Appeal was not valid. Noted that these two issues was decided simultaneously in one Ratio de Serendai, the approach taken by the Federal Court, can be seen in para 43, stated that since the appeal was heard and disposed by the three judges on the Court of Appeal panel, the requirement of Section 38 above are met. Section 42(1) applies only where any judges of the court absent in the court in the course of any proceeding or in the case of a reverse judgment at any time before delivering the judgment. Given that the unanimous judgment of the Court of Appeal had already been delivered orally in open court in the presence of all three judges, the section does not apply in this case. The ratio de Serendai also can be seen in para 44. All right, to sum up, Section 100 of Court of Judicature Act stated that unless the opinion of the Federal Court some substantial wrong or miscarriage of justice has been thereby occasioned, meaning that the court rejected the contentions by the doctors and the hospital based on this section. This one is also one of the ratio, the important paragraph. We're moving on to the first issues is which is what is the applicable standard of care in medical negligence. The decision by the court is confirms that Roger test is limited to advice of rates, while Bolam test and Balito governs the diagnosis and treatments, can be seen in para 61. The important passage in this paragraph, we hold that the Australian case, which was followed by this court in Fufiona in regard to the standard of care in medical negligence, is restricted only to the duty to advise of risk associated with any proposed treatment. It does not extend to diagnosis and treatment. With regard to the standard of care of diagnosis and treatment, the Bolam test still applies, subject to qualification as stated by the House of Lords in Bolito. All right, next, second issue is whether the doctors have the duty to disclose material risks. The Dr. Hari and Dr. Namizi. For these issues, the decision by the court held that the failure to warn deprived plaintiff to making an informed decision is amounted to breach of duty of the doctors. The ratio can be found in the following paragraph 74, 76, come up. Based on these two paragraphs, the court held that neither doctors warned the plaintiff about the risk of bucking and consequent blindness, and number two, a reasonable patient in his position would have attached a significance to the risk. All right, next, moving on to the third issues, whether Dr. Hari is liable for negligence in diagnosis. The court held that Dr. Hari negligent for wrongly diagnosing and subjecting plaintiff to the unnecessary surgery, the second surgery. No evidence of retinal detachment. Second surgery is unnecessary. Can be seen in paragraph 78, the ratio. The passage, the important passage is the Bolam test as qualified in Bolito is to be applied in respect of diagnosing and treatment. In the present case, both the plaintiff expert as before and Dr. Hari's expert as before agreed that the second operation would only be necessary if there was retinal detachment. As noted by the Court of Appeal in the passage above, the contemporaneous documents and testimonies of witness shows that there was no retinal detachment. Moving on to the fourth issues, whether Dr. Namizi is negligent in conducting anesthesia. All right, the court decided that yes, Dr. Namizi is liable. So the reason is stated in para 51. In our view, the very fact that muscle relaxant drug were off is a clear indication of negligence. The fact that the plaintiff did not buck further after top-up dose was given shows that the bucking could have been avoided and controlled by additional drug. In evidence, there was clearly mistiming of top-up dose, since it was not disputed that if a top-up had been given earlier, the plaintiff would not have bucked. The fifth issues in this case is whether aggravating factors should be compensated. All right. To sum up, the decision by the court is yes, the aggravating factors should be compensated. The ratio in these issues can be found in para 99. The aggravated damages can be and have been awarded as a separate head of damage in tort. For example, aggravated damages are frequently awarded in defamation case for injury to a person's reputation. There is no reason to exclude this kind of damages from medical negligence cases which involve real injury to a person's body. The final issue is, can a private hospital be held vicariously liable for the sole negligence of the doctors? The decision is the private hospital can be held vicariously liable for the negligence of the doctors. The reason stated in para 142, we would take heed of proviso in Woodland to proceed with caution, incrementally by analogy with existing categories and consistently with some underlying principle, and to impose liability only insofar as it would be fair, just, and reasonable. To make a broad pronouncement on the liability of all private hospitals in a medical negligence case on the basis of policy alone would risk over generalizing the nuances of modern business relationship and result in an unprincipled approach to liability. All right, I think that's all for the ratio. Next slide would be presented by Brother Faris.
Thank you so much, Mr. Agus. Faris here. Good morning, everyone. Good day. Today, I'll be explaining about the legal basis in the federal court case of the Dr. Hari Krishnan and Anand against Megat Nur Ishak. This case clarified 4 important areas in Malaysia medical negligence law. The first one would be the test of diagnosis and treatment by the doctors. The second would be the test of the doctor's duty to disclose risk to a patient. The third would be the question of whether the hospital can be held liable for the negligent doctor. And finally, whether the aggregated damages can be awarded separately. And the court also referred for a few statutes like the Court of Judicature Act 1964, the Medical Act 1971, and of course the Private Healthcare Facilities and Services Act 1998. So for the standard care in Malaysia negligence, the court confirmed that in Malaysia there are 2 different tests are used depending on the type of complaint. For diagnosis treatment, the test comes from Bolam and Bolito. For the duty to disclose risk, the test comes from Rogers versus Whittaker, which adopted in Malaysia officially through case Fu Fiona. The split system is important because it balances the medical expertise and the patient right. So to put it simple, in the case about how the doctor treated or diagnosed the patient, the Bolam Bolito tests are going to be applied. If the case are about whether the doctor warned the patient about the risk, then the Rogers and Whittaker tests are going to be applied. For the diagnosis treatment, for the Bolam rule and Bolito, the Bolam rule from 1957 says that the doctor is not negligent if they follow the practice accepted by the responsible group of medical experts. However, though, in Bolito cases in 1977, later added as a safeguard, a medical opinion must also must be reasonable and logical. Court do not have to accept an opinion if it doesn't make sense. So the rule today is the doctor are safe if their treatment is both supported by an expert opinion and is logically defensible. When it comes to the risk disclosure, its approach is different. In Rogers and Whittaker, the court said that the doctor must warn patient for the material risk. A risk is material if a reasonable patient would want to know about it before agreeing with the treatment. Malaysia adopt this officially in Fu Fiona cases. This means in Malaysia, when it comes to risk, the court decided what's count as materials, not the doctor. So consensus form alone are not enough. Doctors must explain the specific risks that matter to the patient. To summarize, the diagnostic treatment, court respect the medical expertise but reject the illegal practice. And for the disclosure risk, the court prioritize patient right and informed choice. The next legal question was, can private hospital be held responsibility if the doctor are negligent, even though doctor are not employee but are rather than an independent contractor? There are 2 concepts here. The first would be the vicarious liability, means that employer are responsible for the acts of all the employees. The second would be non-deligible duty, means even if the hospital is contractor, it may still be responsible because it's undertook and provide safe care. The court replied to this important case via Woodland and against Swimming Teacher Association, which explained that non-deligible duty applies, and Ellis versus Walsend District Hospital, which said hospital are not just building but provider who care for the whole system. Aggregated damages are extra damages given when the defendant conduct causes extra humiliation, distress, and insult beyond the normal injury. And the key authority here is through the Richardson versus Salib, which discuss whether the aggregated damages are separated from the general damages. The federal court confirmed in Malaysia that aggregated damages can be awarded separately, but they are not just absorbed into general damages, but treated as an independent head of recovery. I think that's summarized for all of my part. We move on to the next presenter.
Good morning. Assalamualaikum and good morning. I'm going to talk about the impact of the case on the future position. Next. Impact of the case for the future position is divided into 4: patients, hospital, doctors, and law. So of the positive impacts on the patients in future position, it will strengthen the duty to warn of risk. The case clarified that doctor must specifically explain material risk, not just give a general warning. The second part is recognition of informed consent as a right. The judgment will reinforce patient right to self-determinations. And the third point is higher accountability for doctors. By applying both Rogers and Bolam and Bolito tests, the court ensure doctor cannot simply rely on doctor no best. And fourth point is hospital non-deligible duty. And final part is about the recognition of aggravated damages. The patient will suffer not only physical harm but also humiliation, pain, and loss of life enjoyment and receive separate aggravated damages, ensuring more just compensation for suffering. Next. Now we're talking about the cons, the potential negative impact on patient, it will increase the cost of litigations and delay. For example, in this case, it shouldn't happen in 1999, but the final decision was in the year 2017. The next point is about it leads to emotional and physical tools on patients. The patient can sue for negligence in the process, emotionally demanding, draining, and requiring trauma-related trial and appeals. The third point is complex legal standard. There can be a little bit of confusion with the volumes and Roger Dick's application. The fourth test is about the possibility of defensive medicines. And final point is about composition may not reverse the loss. I'm talking about the pros for the hospital in terms of future position. In this case, it will clarify the scope of responsibility of the hospital, where the court must proceed with caution, incrementally, and only when fair and just reasonable in order to determine the liability for the court. Next thing is about the judicial recognition of modern business arrangement. It acknowledges the complexity of hospital engaging doctor as independent contractor, which gives hospitals some room to structure contracts more carefully without always being automatically liable. The third point is for encouragement for stronger risk management, where they need improvement in patient communication, ultimately leading to high institutional standards and reduce long-term liability risks, and also share accountability with the doctors. And finally, and it release guidance on non-deligible duty doctrine by discussing the Woodland and this the federal court provide clear legal guidance on when hospitals are bound by non-deligible duties. Talking about the cons for the hospital, will lead to a lot of potential increases in patient lawsuits. In the case of the hospital, can be vicarious liable for independent doctors, and also in the case of non-deligible duties. They will put a high financial exposure in terms of aggravated damages, which may lead to insurance premium increases, and also the reputational damage of the hospital, where the public image and trust has been tarnished. And it also may lead to operational burdens and also uncertainty in liability boundaries, especially when it comes to the non-deligible duties and also the vicarious liabilities. Next point, focus on the positive impacts on the doctors. It will lead to clarification of the legal standards, so doctors knows what the action will be charged in case of negligence. For example, in terms of Bolton test and Roger will take a test. The next thing, focus on recognition of professional judgment, where court acknowledge that not every mistake, modern negligence decision must be assessed against accepted medical practice and logical reasoning, respect to doctor professional autonomy, and also lead to guidance on patient communication, with share liability with the hospital and precedent for future practice. Next, and the next point is about the negative impacts on doctor. It will increase the duty of disclosure with higher risk of personal liability, exposure to litigation, and damage to professional reputation and emotional and financial strains. Next, the final part that I'm going to talk is about the impact on law. Positive impacts on law, it will strengthen in future position, it will strengthen the patient rights in informed consent. The case will firmly establish dual test system, as mentioned before, is clarify the legal standard, aligning nation with modern patient-centric approach. And the next thing is recognition of the damage in medical negligence, so that this will inform the court can go beyond mere financial loss to humiliation, suffering, and loss of dignity. There will also be a clarification of vicarious liability versus non-deligible duty, also as policy guidance for future cases. And judicial recognition of modern healthcare structure by addressing the independent contractor, hospital policy, and contractual relationships to acknowledge the reality of modern healthcare system. Last point is about the negative impact on law. In the future position, again, I repeat again, it will lead to complexity from the dual test systems, and also broadening the liability with aggravated damages, because recognizing aggravated damages in medical negligence may lead to higher and more subjective award. This creates uncertainty in damages assessment and encourage excessive claims. It will also lead to increased litigation burden, and also limited precedent value and risk of defensive practice and judicial overreach. And the last point is, I would like to make a conclusion on this topic. The federal court in this case, Dr. Hari Krishnan and Megano Ishak, liable for negligent advice, diagnosis, and failure to warn of risk, while confirming that hospital will not vicariously liable for truly independent contractors or patients a non-deligible duty to ensure proper care. The court affirmed aggravated damages and applied dual test system, Bolam for treatments and Roger for disclosure. The case strengthened patient rights, imposes stricter duty on doctors, clarify hospital accountability, and advance medical negligence law with clear liability standard. Thank you.